Hello viewers, my name is Victoria Servan, and in this presentation I will be discussing the wrongful conviction journey of Jeremy Puckett. Jeremy Puckett is just one of the many wrongfully convicted. Jeremy's story takes place in our very own capital, Sacramento. On March 14, 1998, the body of 19-year-old Anthony Galletti was found along the side of White Rock Road in Rancho Cordova, California. Upon finding his body, it was found that he had sustained gunshot wounds to the back of the head. His hands were tied behind his back, and he had no wallet, keys, money, or identification, and his car was found to have been torched a few days later. The case then went cold for a few months. However, in 1999, an inmate at a California state prison named Puckett as the shooter, and with this statement by this informant, Puckett was arrested in April 2001 and was later charged with Galletti's murder in September. During the investigation and the trial, it's important to note that 2 years prior to Puckett's arrest, the inmate, whose name is Israel Sept, approached a prison guard saying that he had information about Galletti's murder and wanted to negotiate benefits in exchange for information concerning the case. With this information, prosecutors then charged Sept with the murder and the robbery of Galletti, since he did admit to being there at the time of the murder. However, after opening statements at Sept's trial, he did decide to plead guilty to the robbery of Galletti and being an accessory to Galletti's murder in exchange for a lesser sentence and promised to testify against Puckett. With this information, police then arrested Puckett and charged him with Galletti's murder. After detaining Puckett, the results of the investigation showed no plausible or physical evidence tying Puckett to the murder, and the entirety of the case was based on this one informant's statement. Another pivotal point in Puckett's journey was that during the pretrial, Sept recanted his original story, and he told Puckett's defense lawyer and the public defender's investigator that he, along with two other people, which didn't include Puckett, had set up Galletti to be robbed at some apartment complex. But this statement never made it to trial because he recanted his recantation statement. And he solely pointed the finger at Puckett, saying that he had in fact murdered Galletti. With a supposedly strong statement tying Puckett to the scene as the murderer, Puckett was convicted of murder and robbery in a jury trial, and according to the Northern California Innocence Project page, the deliberations lasted almost as long as the trial itself, and on March 14, 2002, Puckett was sentenced to life without the possibility of parole. While Puckett was doing time in prison, he first contacted the Northern California Innocence Project, also known as the NCIP, in 2012. And it was at that point when the NCIP uncovered about 700 pages of suppressed materials. In July 2016, the NCIP filed a petition for a writ of habeas corpus at the Sacramento County Superior Court, but it was denied. They later tried again for another petition, but in the 3rd District Court of Appeal, but it was also denied. However, finally, in September 2017, a petition was filed for a writ of habeas corpus in the California Supreme Court, and it was passed. And it was passed based on the lack of physical evidence as well as the suppression of 700 pages of evidentiary materials, which proved to corroborate Sept's original recantation. It was found on March 3rd, the Superior Court overturned the murder conviction against Puckett, and on March 13th, Puckett was released and the prosecution dropped the charges. I did try to see if Jeremy Puckett had received any kind of compensation, but I couldn't find any information after he had been released. So there were a few causes that contributed to Puckett's wrongful conviction, but I want to focus more particularly on the jailhouse informant as well as the ineffective assistance of counsel. So to begin, one of the main components in Puckett's arrest, which was the basis for the whole case, was the false testimony of a jailhouse informant, Israel Sept. Now, I know I keep saying jailhouse informant, so what exactly is a jailhouse informant? A jailhouse informant is an incarcerated individual who either hears information about a case from another individual, like his cellmate, for example, or they personally know information that is pertinent to a case. However, a jailhouse informant might also be known as a snitch, which is a term more commonly known against the public, and it's common belief that if you snitch on someone, you're obviously not looking to make friends in the criminal system or whoever you snitched on. Otherwise, as the saying goes, snitches get stitches. This concept has led to the belief that jailhouse informant testimonies probably aren't the best piece of information to base a case off of, seeing as that they do have a speculation to lie in order to either receive benefits like protection from someone or a lesser sentence. As in the case study conducted by Deloach, Neuschatz, Westmore, and Bornstein, they explored the successful detection of a jailhouse informant's possible ulterior motives or discrepancies in their testimony, which would influence verdict decisions, and in this study, it consisted of 384 participants, and all participants were given a trial transcript and then broken into 3 groups, which consisted of a court trial transcript from a jailhouse informant's testimony. However, the variable in the study was that the jailhouse informant's testimony had been manipulated into containing either an inconsistency, an ulterior motive, or an alternative explanation. After reading the trial, participants were asked to make a verdict decision and attributions about the jailhouse informant. Once the participants had listened to the transcript and made their decision, it was revealed that inconsistent statements and alternative explanations reduced conviction rates, while those with ulterior motives showed to have actually no effect on their participants' decision. Now you may be wondering, well, what does this have to do with Puckett's case? So when looking at the two, they may appear similar in that both the study and Puckett's case, the jailhouse informant testimony was the main piece of evidence that was either going to convict or release the accused party. However, in the context of the research, it's a given factor that any and all evidence was brought to light and was present during the trial and shown to the jury. However, in Puckett's case, the opposite occurred, and Sepp's ulterior motives were not provided to the jury, along with the suppression of evidence. So they were left with only half of the story, and unfortunately, they were left with the story that implicated Puckett instead of releasing him. The second factor contributing to Puckett's case is ineffective assistance of counsel. One might say Puckett's defense lawyer was a bad lawyer, and according to an article by Barry, he explains what it means to be a bad lawyer. And one of the main points is to have minimal preparation or a weak trial, advocacy, superficial and or tentative cross-examination, which Puckett's lawyer was clearly guilty of. Looking a bit closer into how Puckett's defense lawyer was ineffective is that a strong piece of evidence that would have aided Puckett in his trial was at the evidentiary hearing. Puckett's sister provided the defense lawyer with an alibi stating that it couldn't have been Puckett because he was nowhere near the murder site and was in fact staying at a friend's house after being at a barbecue all day with her and their family and friends. This statement, though, was not brought to the jury. In addition, Puckett's defense lawyer did not present an argument in identifying the discrepancies in Sepp's statements, where he went back and forth stating that Puckett was there and then he wasn't. He also did not cross-examine the prosecution's witnesses either, because had Puckett's lawyer effectively cross-examined the prosecution's witnesses, it would have revealed that Sepp's testimony changed more than once, and the witnesses also changed details of their testimony in order to implicate Puckett. In addition, while it's unknown about the physical state of Puckett's defense lawyer, but a possible aspect, according to staff at the Innocence Project, it's been noted and identified that the malfunction of overworked lawyers to investigate, called witnesses, or prepare for trial has led to the conviction of innocent people. However, even if Puckett's lawyer was overworked or not, this did not excuse the lack of effort in representing Puckett, which leads to my next segment, reforms. So for informant reforms, one of the main ideas that has come to light, and is a strong point in fact, is to allow for both the prosecution and the defense to be able to corroborate the testimony in question before allowing the informant testimony to be used in court proceedings. So if both the prosecution and the defense are able to verify and figure out where this testimony has come from and who is actually informing them, it probably would lead to lower conviction rates, and the jury would be able to see what the testimony has to offer to the case and not only be based off an alternative or ulterior motive. Again, referring back to the case, Sepp's criminal history would have been a strong indicator that the defense should have looked into it more, since Sepp's history was a bit questionable. It would also be important to note the tracking of the use of the jailhouse witness testimony to see where the informant got their information and if it's actually any way connected to the case, and to see what connections the informant has made on the inside and outside of the prison, just to see if there's any reason to suspect the informant's willingness to give information and just not to accept the testimony after an initial hearing. For ineffective assistance of counsel reforms, an obvious reform would be to provide defense lawyers with a workable caseload, that they are able to conduct a proper investigation and actually meet with their clients and understand the details of the crimes the defendants are being accused of. However, this reform might take a bit more thought into it due to the fact that the way the criminal justice system is set up now, it sort of pushes the defendant to accept a deal rather than go through a trial, since it is a lengthy process. But with the amount of crime that occurs, and to break down the system only to rebuild it up again would bring the criminal justice system into chaos. However, a more attainable reform, according to Bernhard, taken from his article titled "Wrongfully Convicted Perspectives on a Failed Justice," it would be smart to provide a secondary review of the case, either by another defense lawyer in their firm, or have access to a special group who's dedicated to making sure that each case is being upheld to its utmost standards in order to provide what we the people want and deserve, which is a fair and dedicated counsel. Lastly, another reform is to introduce education or outreach programs. In doing so, by providing information to upcoming and present defense lawyers about the effects of ineffective counsel, it would probably give them a better outlook on what can occur. And in an article called "Bad Lawyering: How Defense Attorneys Help Convict the Innocent," the author Barry probably could not have said it any better in stating, "Assess yourself from the viewpoint of the innocent person charged with a crime someone else committed or a crime that never happened in the first place. From that perspective, are slapdash explanations of law and procedure good enough? By implementing the seed to think of how one would like to be treated if they were the defendant rather than being the defense, it could lead to better representation." Not only could these education and outreach programs be applied to people working directly in the criminal justice system, but also be available to the public. In the media, the public is given information a majority of the time about how the proceedings of the prosecutor works. However, the proceedings and responsibilities of a defense lawyer are barely mentioned, if at all. By providing the public with this information, it provides the people with the knowledge of what it means to have a good defense lawyer. And this concludes my discussion on the wrongful conviction journey of Jeremy Puckett. Thank you.